for your second. Okay, Chair Best, we are live. Thank
Okay,
you very much.
I hereby call the May 8th Frostburg Plan Commission meeting open. We'll begin with the roll call.
Richard Russo, Eric Stevens,
Conrad Bass, Chairman.
Karen Crone.
Jeff Snyder, Ray Race.
All right, we have a quorum. I would ask that anybody who is here to present meetings before the commission to come to the podium, state your name and your address. The business that you are coming forward. Each meeting is recorded, so please speak loudly and clearly. First item on our agenda is the review of the February minutes. Each of you have a copy. Please take a minute to review them.
Don't have much on the agenda. I would make a motion to accept the minutes of the February meeting as written.
Have a motion to approve the minutes as written. Do I have a second?
I'll second.
All in favor say aye.
Aye.
Opposed? Abstentions? Motion carries. This is the time in the meeting where we open the floor for citizens' comments. I see we have citizens here. Are any of you here to bring anything to our attention, or are you just here to observe the?
I have something to say.
Okay.
Hi, my name is Diane Wilson. I'm president of Frostburg Rental and Sales at 227 East Main Street. And I'm here tonight to really just provide some information. We have had our building for sale, and Mr. Rob Boyle, who owns and operates Rehab First next to our building, is proposing to put a cannabis dispensary in that building. Rob is a very good businessman. I know he is planning to put a very respectful business in there. Along with purchasing our building, his plan is to purchase the corner market and the house next door there and put parking in there. And I know cannabis dispensaries are a major issue with the new House bill that just passed here in April and goes into effect June 1. That's going to have some bearing on whether or not, he is able to do that with zoning and everything else. But I just really wanted to let the board know that it is, he is planning a very respectable business there. And, as you're doing your considerations on zoning and the new House bill, I think it's a good thing for Frostburg. It will bring a lot of revenue into Frostburg. They are, high revenue businesses. But I just really wanted to let the board be aware of, the proposed intention, and hopefully it is something that can work out here in Frostburg for him and for us as well, as we can sell our building. We have a construction company, we'll be doing the build out on the building to make sure it meets all the regulations.
Which building was that?
It's the Frostburg Rental and Sales Building at 227 East Main Street. So he has all of his license, and for the dispensary, it's now finding, you know, a viable building that he can open the business. It's going to probably take 6 months to do that, but regulation and they're just, cannabis dispensaries are kind of a hot item right now on where you can put them or not. But he is planning a very, very respectable business there. So, thank you very much.
Thank you.
It's been a while. 8 years. Shrine Overton,
Really?
6 South Mount Vernon Street. 8 years.
Oh my goodness.
And that's crazy. I'm here with Denny Delaney here today. I live about, I'd say, 50 feet maybe from the building that we're talking about here. I do have a whole history of that building, as my grandparents put that building there. That was their service station for many, many years before they sold. And I talked to Bethany, I think, last month about, you know, the new law coming into effect and all that with cannabis sales, and knew that you guys were going to get to the point where you are going to be discussing that, discussing how it's going to work. And that's mostly why I was coming up, just to do some fact finding about how that would work. Because we're looking at a C2 zone, which is where this building is located. And it's an interesting C2 zone in that it is a very small island of a C2 zone with residentials all around it. The one thing I just wanted to say, as I look through the state's new guidelines, is that law now, or is that a
It
going
goes
into
into effect
June
June
1?
1st.
Okay, so the document you put up was, that is it. Well, I know that they did recommend in there that get a political subdivision. Of course, you guys are going to put things into ordinance because, as it is right now, cannabis sales is not anywhere in the right. So that's a new business, right? And I talked to some people about it. It's like, yeah, that's a very new business. So obviously, we'd have to go through an appeals process and all that. But the one thing I did notice in that was it said a political subdivision may, by ordinance, establish a distance limitation of dispensaries up to 100 feet away from an area zone for residential use. And I feel that is very reasonable, and would just ask the commission that as you deliberate these things, that might be one of the things you put into it, because, like I said, I think that is a very reasonable request. And as the state actually puts it in there specifically, you feel like that's something they are very okay with. It would stand up in a court. So that's my only statement. Thank you.
Okay. Now that we've had those two comments, then we will go on to the next item of our discussion, and that is House Bill 805. And you've all got a copy of it, I think, in it. Bethany, I know I asked you earlier, and I know you replied in an email, and I must confess I didn't read it before I left. What is it we're looking for out of this?
So as we begin, I just want to ask you all to be mindful that what we're talking about tonight is not property specific. This is where the use of a cannabis dispensary may or may not be located within our zoning district. So what I'd like to do tonight is walk you through the parameters of this House Bill 805, and some of the things that are in here are not applicable to Frostburg. Some of them apply to cannabis businesses that were already in existence in the municipality before a certain date. So many of these items don't apply to us, so I'm going to walk you through the things that do. And then I would ask that we take a look at our current zoning district regulations and figure out how you all would like the cannabis use to fit into each of these zoning districts while abiding by the law.
Okay.
All right, so if everybody's ready, we will go ahead and dive in. I'm on page 5 of your packet. There is nothing on page 5 that I'd like to discuss with you. So if you flip over to page 6, we are almost to the bottom, section DD1. Okay, under article, alcoholic beverages and cannabis. And for those in the audience, let me put this up on the screen for you so you can see where I'm looking here. So first, I want to draw your attention to the definition that the state gives of a retail dealer. A retail dealer means a person that sells an alcoholic beverage to a person other than a licensed holder. I was put in contact with a person named Morgan Smith at the Maryland Cannabis Administration. They have been a wonderful resource to me so far. So I did ask for clarification on this point, because I was a little unclear whether that meant just a liquor store, or does that mean a bar that serves alcohol? The latter is the case. Any place that serves alcohol, whether it be a bar, a restaurant, or a liquor store, they are considered retail dealers. So I just wanted to bring that to your attention as we begin here. So, page 7 doesn't have a whole lot that is going to apply to us. So let's go to page 8 of your packet. So, for those in the audience, I'm scrolling to this page now. So, subsection B that begins, except as provided in subsection D of this section, a licensed dispensary may not locate within 500 feet of a pre-existing primary or secondary school in the state, or a licensed child care center or registered family child care home under Title 9.5 of the education article. So that would be a home-based daycare center. That's number 1. Number 2, a licensed dispensary may not locate within a pre-existing playground, recreation center, library, public park, or place of worship. And then number 2 that immediately follows that, it may not locate within 1,000 feet of another dispensary. That doesn't apply to us.
Yes.
Yet. So then it goes on to say, except as provided in paragraph 2, a political subdivision may adopt an ordinance reducing but not increasing the distance requirements under subsection B. So that means that we can say 400 feet from a playground or a child care home, but we can't say 600 feet.
Right.
The next portion here, a political subdivision may by ordinance increase the distance limitation for dispensaries under subsection B2 of this section to not more than 1/2 of a mile.
We're referring to, it's capital B, so now we're back a couple pages, is that correct?
Yes, that
Okay.
capital B is, sorry, just give me 1 second.
It's over here on page 7.
Yes, it's on page 7, it's right at the beginning. A political subdivision may establish reasonable zoning requirements for cannabis businesses and decide how to distribute its allocation of revenue under the tax general article.
That don't make sense.
Yeah.
And I just also want to say, if there is anything that we discussed today that you'd like me to get clarification on from my contact at the Maryland Cannabis Administration, I'm happy to do so.
I think that would actually be little b2, because that's what actually refers to, it says under subsection little b2 of this section.
Yeah, I think
So
so.
notice how the whole thing is, and they get in trouble with this all the time.
Yeah.
Because whenever they make a change, all changes are done in all caps and underlined and italicized. So they don't differentiate between capital B and little b in subsections.
Yeah.
So this actually refers back to the 1,000
To
feet
small
of another
numbers, yeah.
dispensary. So we cannot increase any of the numbers except for B2. We can say we can only put 1 every 2,000, which basically means you can put 2 on Main Street. that's about it.
Thank you for that.
Okay.
All right, commissioners, I am now on page 9 of your packet. So, this gives a few more provisions here. The one that I'd like to bring to your attention is line 2, section E. A political subdivision may not adopt an ordinance establishing zoning requirements for licensed dispensaries that are more restrictive than zoning requirements for a retail dealer licensed under this article. So that right there is the meat and potatoes of our discussion. Any zoning district that we currently have that permits alcohol service, we are not able to create more strict regulations for cannabis dispensaries. So I'd like to skip down to a political subdivision may. This is part G on that same page. A political subdivision may, 1, by ordinance, establish a distance limitation for dispensaries of up to 100 feet from an area zoned for residential use. 2, apply to dispensaries the distance limitation for licensed alcoholic beverage retailers from an area zoned for residential use. This would only apply to us if we already had those distance regulations for alcohol retailers, which we do not. So really, we're looking at part 1 there, that we may, or you may, establish a distance limitation from residential uses of up to 100 feet. That's the maximum that you can impose. And then everything else refers to protests that may be filed against a license renewal. That would apply to members of the public, not necessarily to what we're discussing this evening. So does anyone have any questions at that point, or at this point?
Yeah, so under, going back a page to page 8, subsection B1, 500 feet, registered family child care home. Say we approve one that is within 100 feet of the residential district, does then that preclude anyone within the next 400 feet from registering a child care home?
That is a very good question. I do not know the answer to that, but I'll reach out and find out.
Yeah, I mean, is it reciprocal, and what would prevent them from coming in, them being the second guy on the block, but yet, you know, it's always been residential? Are you taking away their right to use their residential property for a child care home when you zone that and put a 500-foot restriction on the cannabis itself?
Right.
Yeah, did they intend for it to read as everything is pre-existing? So is it pre-existing primary, secondary school? So under that scenario, if it's pre-existing, then,
Well, it says registered though.
yeah, I
And
know.
that's what gets me though, is, you know, I'm within, I'm in a C1, but the property behind me, I think I'm C1, or maybe C2, but the property behind me is residential. So if my property turned into a cannabis dispensary, which I don't see that in the near future, but if it did, would that preclude someone on Washington Street, which is within 500 feet from me, from opening up a child care center there because I've already claimed my 500-foot circle?
I don't feel that it should. Because there's no restrictions, if there's no restrictions on the child care home within that district, it would be the business owner's choice to put it there. And then having the dispensary there would essentially have it grandfathered within the 500
Pre-existing.
feet.
yeah, I mean, that's why I'm reading it, because that's the pre-existing, so it's, if there's nothing there, somebody puts a business in, it doesn't preclude either one. Now, you might have a question, nobody else, but then nobody else could locate anywhere because what is it, 1,000 feet from the next one, right? So you wouldn't have to worry about somebody coming and locating within that area. So, but I'm going back to the pre-existing. So the pre-existing would be, somebody then could, if they wanted to, put one of these other 4 businesses where it's approved in a residential area. And, I guess the question is, because like you said, it'd be grandfathered at that point.
That's how I would interpret
Yeah.
that.
There was something in what you said earlier,
That's all I wanna know.
What's that?
there was something in what you said earlier because of the definition of a retail, business. That means that any place we currently have liquor stores or bars or restaurants that dispense alcohol, then that automatically means that we must put a dispensary in that zoning category?
It means that zoning districts where that use is, let's say, permitted by right,
Right.
then a dispensary would have to be permitted by right. If it was permitted by special exception, then a dispensary could, only be permitted by special exception or by right.
Okay.
But as you were saying, we don't have existing alcohol district.
We don't have distance limitations for alcohol service. So, some municipalities will say you can't locate a business that serves alcohol within 100 feet of a residential district. We don't have those district limitations, we just have whether the use is permitted or not.
Right.
So we have to be very careful when we look we're gonna have to look at each one of our, classifications.
Yes, so, at the very beginning of part 3 of your zoning ordinance, there's a chart that, it distinguishes what kinds of businesses are permitted in which district. So, really what we need to look at here is, the parameters that we allow in each district. So, looking at this, bars, lounges, and taverns are permitted by special exception only in C2, and they are permitted by right in C3.
What page are you
I am at the very I'm not sure.
on?
of
I'm
what
not
page
seeing the
it-
bars.
I think it's 33.
Yeah,
I'm not sure if Karen has it.
It's in the handout. The handout's different than the
Oh.
book. The pagination's different.
It's 33 in the book,
Okay.
33, 130.
Here, Karen, I'll give you my packet.
Oh, I see.
I'll share.
You're good.
Okay.
Yeah.
Thanks,
Should
Trevor,
be
for
on
that one.
it should be on the third page.
Oh, no, I'll take it.
Okay.
I was gonna share with him, but he's got it.
There you go.
Oh, no, yeah, okay. She said they're only
So it's just C.
What about restaurants that allow alcohol as long as they're a restaurant?
We have to consider that. So we'll need to go through each of the district regulations and determine which districts that's permitted in. So I can say up front, in R1, R2, R2A, R3, and R4, alcohol sales is not permitted, and actually most commercial uses is not permitted. So, those are kind of our low-hanging fruits for discussion. Moving down the list through our zoning districts, the RO residential office district That also does not permit, restaurants or liquor stores, retail, anything like that as a by right use. And then it's also not a special exception use. You all can decide if you'd like to permit dispensaries in any of those districts that I just talked about. So why don't we start there?
So the R3 and R4 has restaurants by special exception.
Okay. Well, then
So,
I apologize.
By that definition, they can serve alcohol as long as it's a restaurant serving food, correct?
That's my understanding.
Yeah. If you, just throwing some stuff out here, if we kept the 100-foot separation from residential, that's gonna preclude a good bit of our downtown commercial developments. Because almost all of our commercial development borders a residential street behind it.
Right.
Yeah, and the 100 feet distance from a residential use, if we impose that on cannabis dispensaries, we cannot impose any restrictions that are greater on cannabis than we would on alcohol. So then we would then
Yeah.
have to impose that restriction on a retail dealer of alcohol as well.
And we can't do that because half the bars downtown have people living above it. So we have a lot of mixed use.
You know, I mean, we want mixed use, I mean, that's,
I'd be more concerned truthfully about all this would be the drive-through component that I see with the dispensaries in Cumberland. And I know they're problematic in the two locations that I'm thinking of, one at Moose Curve and one on Industrial Boulevard. They're not designed to handle the amount of traffic that comes through them. And, you know, we had the same issue in here, or we had the same issue before with some people wanted to put drive-throughs in with restaurants where they just couldn't get enough stacking for the vehicles. So that'd be one of my biggest concerns with the cannabis and paralleling with alcohol sales. Do they intend to do drive-through? Because it seems to me like that's a big business component to what I've seen. I mean, you go downstate, you see the same thing. They all have drive-through service.
no,
Most of them do.
Yeah.
all drive-through require special exemption, right?
Yeah.
I am not 100%.
I thought we,
I thought that
Yeah,
the
I
end
think
would
we're pretty
change
sure.
that.
I know in C2, it's definitely a special exception.
C3 it is also.
Yes, C3 it is.
And it might actually be in C. I thought we had it.
C4
C4
does permit
permitted.
drive-through service.
Yeah.
okay.
And TLI does not.
So I
So
know
there's
the,
nothing downtown.
I know the law kind of is spending all this time equating cannabis with alcohol in the sense, I guess, that they're both like, you know, sinful activities. But, you know, I'm kind of curious if there's been any lawsuits in other communities. I see, as someone who has an acute sense of smell, it's the stank, right? And so, you know, I don't see them as equivalent businesses in that sense. Like, I was looking for, is there a business that stinks, right? And then are there sort of setbacks from that? I guess what I'm saying is, you know, is there some, if there's a community that hasn't put up like a distance barrier, you know, has somebody sued that municipality for kind of basically an administrative taking of their property, because, you know, they're constantly being permeated by marijuana smell. So it's just something to think about, like,
Yes.
Yeah,
because
driving past Moose Curve every day, it is very noticeable.
yeah, so I mean, somebody could sue saying that, you know, we created a policy that takes away the enjoyment of their property. It would be interesting to see if you know, if there've been cases that have been filed against municipalities that haven't created a buffer.
Seems like the emphasis of this House bill is to try to prevent discrimination. I don't know that they're really all that concerned with the zoning so much as, it seems like it's really slanted towards anti-discrimination against the dispensaries.
But it would be discrimination from a zoning standpoint, saying you can't bring your business here.
Right.
So that's what the state is trying to deter.
Yeah. They're encouraging.
On
Taxing it for crying out loud.
the correlation we were making between the alcohol and cannabis was based on the definition in the bill, right? So that's why we're
Yes.
comparing the two.
I mean, the closest on the list I saw here was like fast food, right? Like, maybe like living next door to Burger King's with constantly flame broiled smoke coming out of it. You know, I was thinking like, and again, in terms of nuisance law, I didn't really see anything else on the list that kind of could generate a smell that's always there.
Questions running through my mind at the moment is, okay, so it's a special exception to have a restaurant where you're serving alcohol in a residential area. I'm trying to think, what processes do we make them go through to get that special exception? I know they have to come to us to see if it's meets the criteria, and then it has to go to the Board of Public Appeals, zoning appeals.
Like the beach club, they had to have a special exception, right?
That's correct, yeah. So this would mean that since we had the beach club there, then we could have a dispensary in that area also? Or we're almost being,
Well, the
We're-
beach club
okay.
obtained a special exception
Yeah.
to do that, so,
so that means that somebody could come to us and for a special exception.
That's something to think about too, is if the special exception was granted for alcohol, and really they've changed our definition of alcohol to include cannabis by this law. Does that mean they're automatically granted that special exception to carry over to cannabis?
I wouldn't say the way you said it, but I could see lawsuits coming
Oh,
on that question.
I
don't think it's answered,
not
but
clear enough in here to determine one way or the other, but I could, like, you know, Jeff was saying, it would be easy to take either side and argue either side on this.
Each case would have its own set of parameters as to why the special exception is granted.
Yeah.
Whether it's strictly just alcohol or if it's the location of the business in relation to selling the alcohol.
Usually it has to be, oh, I'm sorry.
That's okay. So it would, each case would have to be looked at individually, but there is some precedent set there by granting that.
I think I'd argue that if I had the special exception, like in the beach club, we'll just say beach club, because it's probably the closest thing in recent memory. I have my special exception to, what was the terminology used in this? As a retail dealer, because that's what they are by definition. Then by that, since the state has changed the definition of retail dealer and has purposely went to make it inclusive of cannabis, that inclusivity would include that particular use at the beach club also. I could see that argument being made in front of the judge. Stuff to think about. I mean, it's a legal question more so than anything.
Does this law allow someone to open a shop and you sit around and smoke it right there? Is that part of the
No, sales only.
dispensary? Okay.
Well, let's see, then that contradicts what you were given by definition of retail dealer. Because didn't you say retail dealer was someone who sold alcohol for consumption on place?
Yeah.
There's a lot of ambiguity in this from the zoning end that's created by this change of definition.
Has the city attorney looked at this thing at all?
He's not given us his official determination on it, but he has.
Okay, we've come up with a question or two here that,
In 15 minutes, we've come up with a bunch of questions that we can't answer, and we're not gonna be able to answer with this. And I think it'd be remiss as a board to go ahead and say, yeah, let's do it and adopt it this way without having some legal advice as to what kind of trouble we get into for like the special exception uses that are being granted and what we're talking about. And, my big thing is consumption on site. I think of the smoking lounges. I can honestly see smoking lounges becoming a thing now, like that.
So
already
instead
have
of
smoking
making any
lines, which is
decisions, why don't we compile a list of questions that we have, and then I will schedule a call, with Morgan, and we won't do any text amendment proposals or anything, but we will continue this discussion next month. Would that be agreeable to you all, so we just have some more information?
Yeah.
Okay.
I just don't wanna see you guys get backed into a corner by someone and open up a whole nother can of worms in our residential districts.
Right.
Because we do have a lot of alcohol sales right in residential district or right next to a residential district. And, people's opinions on cannabis don't necessarily follow the law in this area. And people are entitled to their opinions.
Has Maryland State Planning put out any guidance yet on this?
No.
Yeah.
I would probably advise to just throw it because someone's gotta ask and the more they get hits on this, they're gonna have to do something. Cause otherwise we're all flying in the dark.
Yeah, it would be nice. This is kind of something that MSP should put out for you guys as training. This would be an ideal training. How do you handle this?
I agree, I would appreciate that very much.
So that'd be one I wouldn't mind sitting in because I'd kind of like to hear their take on some of this.
Yeah.
I'm looking at the bottom of page 6, and I feel like there's some wiggle room built into it, or at least, opportunities for lawyers to make money. With the unduly burdened, this is like line 32 at the bottom. So it says in this section, unduly burdened includes imposing a zoning requirement or restriction on the use of property by a cannabis licensee that is more restrictive than the requirements established 36.410, which is what we reviewed on page 8. So what's the idea of unduly burdened, like in the sense that, if you did put a residential buffer, I could see it like if the residential buffer in a place like Frostburg meant that basically a dispensary couldn't locate pretty much anywhere, that would be unduly burdened. But if it said that, I don't know, 50% of the commercial, like, to me, that feels like a place where there would be legal wrangling. So, I don't know, like, again, it's guidance from somebody. I can't believe there aren't other places that have already.
Yeah, Jamie, I have a request. How much access do you guys have to the city GIS? Could you throw something together real quick?
Essentially showing where.
Show our C2, show our permitted districts, and then throw a 100-foot buffer around them and show what the impact is to the adjoining districts. That'd be interesting to see.
Yeah.
Yeah, I can, work on trying to do that.
I could see if our GIS center on campus could do it for free. Be a good student project.
Yeah,
And it'd make a nice student project.
I'll tell them it's about cannabis. See if it like generates some interest.
So right now, liquor stores are C2 and C3. C2 and then C3 is special exemption, right?
C2 is special exception and C3 is permitted by right.
Okay. Yeah. Because again, I mean, because you can't consume on site, it's almost we're looking at it more of a liquor store. I think if when the time comes, and it might come to where you can consume on property, it's a different beast than what we're dealing with right now. I mean, when you look at it, if we're gonna equate it apples and apples, you know, it's the same as a liquor store. If that's how we're gonna treat it, we're treating it as a liquor store. So, you know, as we were saying, if you could map that, that'd be good to see where at least those would hit and what we're talking about. And again, you know, we might want to try to get this out to the public. So, I mean, this is what we're looking at. Once we get down that road, it's like, we'll be able to visually show what we're talking about.
I don't understand why they couldn't consume on site. It's a private property. I mean, you're only restricted from public use.
but there is the potential of nuisance in terms of the air quality.
Yeah. I mean, seriously, it's public, you're not allowed to consume in public property.
Yeah.
But on private property, and even though a business is open to the public, it is not public property, it is private property.
That's something, whenever they suspend open container laws for special events uptown, that would essentially open that up to allowing that to take place on public property or, yeah.
Yeah, that's gonna be an interesting, derby day. The reality of it is people consume it now on, you know, in public and in private. And that's nothing that we do in here is going to change that. But I think the important thing is this, we gotta make sure we keep the city out of the lawsuit for someone, A, who wants to move in, or someone, B, who's already living here and has someone move in next to them, or converts their business next to them. So,
And the bigger one is, as you were saying, is most of these now have a component of drive-through. And that's gonna be problematic because traffic.
I was gonna ask Diane, do you have any idea whether they're planning on
I
driving?
do not, I messaged someone to find out if that was an option. I will find that out. And I do also think before you can get a license to dispense this stuff, they have regulations as well, you know, as far as not using on site and different things. But I will find out about the drive-through.
I didn't know if it would lend itself to that.
I don't think the building necessarily would, and I think that's why it was creating all the additional parking where the corner store was, rather than having a drive-through, having parking.
That's a fair amount of walking from from where you're talking about parking lot.
Well, he was purchasing the corner market and
Right.
the house next door, and then right next door is the rehab.
Oh, yeah, I'm sorry.
His
I'm,
physical therapy
yeah,
unit. And
I'm
then-
thinking in the wrong direction.
Yeah.
Sorry. I was thinking it was further down, Main
No, no,
Street.
he's
Yeah,
willing to,
it's right,
you know,
yeah,
certainly work with and accommodate,
it is right
he would like
next
to
door.
put it in that building,
I didn't know if there would be an alleyway that,
there is an alleyway between the rehab first and that, there's an old house there, and then the corner market, there is an alleyway there, yes.
which could potentially be a drive-through.
I guess could possibly be, but I will find that out.
I'd also like to mention that a business expansion like this would require a site plan review from this commission, regardless of whether a special exception is requested. You know, so the process for something like this in a special exception district would be they would come to you for the favorable recommendation, go to the Board of Zoning Appeals, and then come back for a site plan review. So, just
Hate to lose the only hardware store we have.
So, as we've been talking, I've been making a list of the questions that you have. We'd like to address how this is handled in mixed-use districts. In residential districts where alcohol sales are permitted, there are a few. What was the language? Unduly burdened, further clarification on that. The question of on-site consumption versus carry away only. How that affects open container laws. That wouldn't be something that you all would be, presiding over. That would be a city code change, not a zoning ordinance change. And then also, how we handle drive-through. And I mean, that is something to consider. Would that be, you know, in a district, for example, you know, well,
There's only two places we have allowed drive-through at the moment, right?
right.
Yeah.
So, are there any other questions that I missed?
I'm sure when you come back, we'll find more.
Well, if you have any questions,
Yeah.
or if something comes in your head after you go home tonight or later
Yeah.
this week, you can always send that to me in an email and I will certainly get the answers for you.
Okay.
I like the idea of the GPS
Yeah.
graphic, that would be interesting.
All right, we beat this guy to death at this point. We're ready to move on.
Would you like to vote to table the discussion until next month? Would that be appropriate?
I'll make a motion, we can table discussion next month with Bethany addressing items that she had.
I have a motion to table. Is there a second?
Second.
Been moved and seconded. We table this for next month. All in favor say aye.
Aye.
Opposed? Abstentions? Motion carries. All right. Administrative business and communications, do you have anything?
We don't have anything on that one.
Okay. Staff reports.
Yes, so I just wanted to give you a quick update that the mayor and council did vote to award the comprehensive plan rewrite contract to Wallace Montgomery. They're based in Hunt Valley, Maryland. The contract is not signed yet. The city administrator is out of town this week, but once she gets back, we expect that that will be signed very shortly thereafter. We did have a preliminary call with our project manager, and I'm even more excited than I was before. He is very knowledgeable, and their team, they've really got some great resources and some great minds behind what they do. So, we just wanted to give you that update. There will be an official kickoff meeting within the next couple weeks once the contract is signed. and we'll have more information for you at that time.
Care to tell us what the price tag was?
I didn't bring the financial.
I can look it up.
That's it, wow.
If anybody wants to look, if they haven't seen it, we have the technical proposal for the comp plan. But I can bring them over.
Did you go through?
I was on the committee, and I can tell you that this is the only one that I saw that I wanted to work with, really.
I can say every reviewer gave them a perfect score. They got perfect scores all across the board. So, I think that really, and we had some tough graders. So I think that really speaks to the quality of the work. The contract was awarded in the amount of $193,022.
Okay. I couldn't understand how 3 PhDs
You're right, yeah.
submitted that one proposal. That
They have a lot of
Not this
admin
one,
staff
one of the
too.
other ones.
They got a pretty large firm. I was very surprised.
So what did you get proposals from?
This was the only Maryland-based company. We got
One was
from
for-
New York City.
called the Research Associates.
And then there was one from Virginia,
Yes. And
who
their
who
names.
had done work in Maryland. Took a while to review that one on Procedural.
Oh, no.
Yeah, this was all day.
That's gonna be a busy year.
When would we anticipate a schedule from?
I'll know more about that once we have our official kickoff.
Have they found out though that City Hall is no longer City Hall?
We will be sure to make them aware.
But they have a planning department that's 100 people. It's a good company. Yeah. I've worked with Willis Montgomery on the engineering side, and they are without a doubt a top-notch. They're an ENR 500 firm, so we're getting good people here. So.
I've definitely gotten that impression. And the other comprehensive plans that they've worked on, they're working on several in Maryland right now, and they're incredibly impressive. And their documents are a lot more user-friendly than our current plan, which I feel is a huge barrier with what we've got now. You know, whenever we're trying to coach people on Board of Zoning Appeals, and requesting special exceptions and things like that, it's difficult for people to be able to call the information they need from our current document. So I really feel that this is going to be a huge upgrade for us.
Okay, is that it then?
That's all I have for you.
All right.
I'll make a motion to adjourn.
Second it? All right, moved and seconded, we adjourn, all in favor? Aye.
Aye. Conrad, before you ask for one.
Abstentions?
Conrad, before you
Motion
ask.
carries. Thank you.